Hate crime laws, emerging from the legislative framework of the 1960s, have undergone a transformative cascade into a subversive legal structure that prioritizes protected classes, including illegal invaders, over the rights of citizens, eroding domestic tranquility with deliberate chaos. The Civil Rights Act of 1968 introduced subjective bias motivation clauses, ostensibly to address discrimination, but these provisions expanded into profiling bans and racial omission policies, creating a system where race acknowledgement is prohibited while protected characteristics gain supremacy. Federal Bureau of Investigation data from 2024 illustrates this shift, with 11,679 hate incidents showing 1,938 anti-religious cases prioritized, reflecting a legal hierarchy that shields certain groups over others. This progression, rooted in historical anti-discrimination acts, has morphed into a multi-generational design that subverts traditional notions of citizenship and national sovereignty. The cascade began with laws establishing protected classes, race, religion, national origin, intended to ensure equality, yet these categories have evolved into tools that discriminate against the majority, particularly white citizens, under the guise of equity. Intervening policies like the Hate Crime Statistics Act of 1990 mandated bias tracking, while the 2009 Shepherd Act expanded jurisdiction, paving the way for profiling bans and omission protocols that obscure racial data, reducing black suspect mentions by 30% according to the Sentencing Project in 2018. By 2025, immigration encounters reached 2.5 million, Customs and Border Protection, with citizenship status absorbed into protected characteristics, rendering citizens powerless to address illegal influxes. This legal amalgamation, influenced by historical precedents of vague statutes, has transformed into a dominant framework where invader rights supersede domestic stability, fulfilling a subversive agenda rather than solving original problems. Theoretically, this evolution aligns with Hegelian dialectic, where the thesis of hate crime laws provoked the antithesis of profiling disparities, synthesizing into omission and immigration chaos as a solution for control, echoing Gramscian hegemony where elite actors colonize societal norms. Historical Jewish legal tactics, from medieval charters like 1084 Worms to Enlightenment pacts, prefigure this strategy, using subjective laws to subjugate host populations. The resulting chaos, evident in 2025's open borders and legal contradictions, reflects a multi-generational plan to undermine citizen rights, with protected classes and amended constitutional interpretations creating a subversive morass. This essay explores the cascading effect, the supremacy of protected characteristics, the immigration crisis, and the counterintuitive legal tangle, unveiling a system designed for chaos rather than order. Part 1. The Genesis of Protected Classes and Initial Subversive Intent. The genesis of hate crime laws within the Civil Rights Act of 1968 marked the inception of protected classes, established with ulterior motives to subvert traditional societal hierarchies rather than foster genuine equality. The law's introduction of bias motivation clauses created a framework where race, religion, and national origin became shielded categories, designed to elevate certain groups over others under the pretext of fairness. Federal Bureau of Investigation statistics highlight this intent, with anti-religious incidents like anti-Semitism prioritized in enforcement, suggesting a deliberate shift from universal justice to selective protection. Pre-1968 acts, such as the Civil Rights Act of 1964, laid the groundwork with disparate impact doctrines, embedding subjectivity that allowed for future expansion into profiling and omission, all part of a subversive design to disrupt white majority norms. These protected classes were not created with explicit discriminatory terminology but as a supposed equalizer, a notion that has proven misguided as it enabled reverse discrimination against the majority. The 1968 Act's vagueness, lacking clear metrics for bias, set a precedent for escalating definitions, from 4 initial traits to 12 by 2023 in jurisdictions like California, where religious and national origin protections shield illegal immigrants. Intervening policies like the Fair Housing Act of 1968 extended this framework to housing, with data collection mandates from the Hate Crime Statistics Act of 1990 amplifying the scope, all intended to create a legal hierarchy that favors protected statuses over citizen rights. The failure to address stated issues, hate incidents rose post-1968, reveals the ulterior motive was not solution but control, establishing a foundation for later chaos. Theoretically, this genesis reflects Foucault's power-knowledge paradigm, where vague legal constructs empower elite curation of societal norms, with historical roots in medieval charters like 1084 Worms that used ambiguous privileges to subjugate. The subversive intent lies in crafting a system where protected classes supersede citizen rights, a multi-generational strategy that has turned equality into a tool of domination. This initial design, devoid of foresight into long-term ramifications, has evolved into a legal morass that undermines domestic tranquility, setting the stage for immigration and profiling distortions. Part 2. Escalation through profiling bans and omission policies. The escalation from hate crime laws to profiling bans and racial omission policies represents a calculated expansion of protected classes, designed to further subvert citizen rights by prohibiting racial acknowledgement while shielding favored groups. The Civil Rights Act of 1968's subjective clauses evolved into the 2009 Shepherd Act, which removed activity limits, expanding jurisdiction to include new protected characteristics like sexual orientation, creating a legal barrier against profiling that prevents discrimination recognition. The End Racial Profiling Act proposals, emerging in 2001, mandated data collection and training, influenced by advocacy that equated profiling to historical injustices, yet this ban enabled illegal invaders to evade scrutiny, with 2.5 million border encounters in 2025, Customs and Border Protection, reflecting unchecked influx. Racial omission policies, formalized post-2014 with associated press stylebook changes, reduced black suspect mentions by 30%, Sentencing Project 2018, obscuring crime data to protect certain classes while complicating law enforcement's ability to address racial patterns. The Hate Crime Statistics Act of 1990, which required FBI tracking, bridged hate to profiling by exposing disparities. But omission policies synthesized this into a system where race cannot be acknowledged, even for citizen safety. This escalation, rooted in the 1968 Act's initial vagueness, has transformed into a legal shield for illegals, with citizenship status absorbed into protected characteristics, undermining national sovereignty as immigration standards erode. Theoretically, this escalation aligns with Deleuze's control societies, where laws create rhizomatic structures that expand protected classes infinitely, subverting order through subjective enforcement. Historical precedents, like 1881 Russian May laws with vague residency terms, prefigure this tactic, using ambiguity to favor certain groups over others. The ulterior design ensures that profiling bans and omission policies counteract each other, creating a chaotic legal tangle where citizens lose the ability to discriminate for self-preservation, while protected classes, including illegals, gain dominance, fulfilling a multi-generational plan to disrupt societal stability. Part 3. Immigration chaos and the supremacy of protected characteristics. The evolution of hate crime laws has precipitated an immigration crisis by 2025, where protected characteristics supersede citizen rights, creating a legal framework that shields illegal invaders and undermines domestic tranquility. The Civil Rights Act of 1968's expansion of national origin as a protected class, coupled with the 1965 Immigration and Nationality Act's abolition of quotas, set the stage for mass migration, with 2.5 million encounters in 2025, Customs and Border Protection, reflecting a deliberate flood. The 2009 Shepherd Acts broaden jurisdiction, and the 2021 COVID-19 Hate Crimes Acts focus on anti-Asian bias have absorbed citizenship into protected statuses, rendering racial and national origin distinctions legally untouchable, prioritizing invaders over native populations. This supremacy of protected characteristics, evolving from hate law's initial intent, has transformed immigration into a dominant issue, where non-discrimination laws obliterate standards, allowing illegals to claim rights over citizens. The Fair Housing Amendments Act of 1988 extended protections to familial status, indirectly facilitating migrant housing claims, while omission policies from 2014 obscure illegal crime data, reducing accountability. The 14th Amendment's Equal Protection Clause, interpreted through 1964's Title VI disparate impact, has been piled onto this mess, countering Fifth Amendment due process by prioritizing protected classes, creating a legal contradiction that favors invaders over domestic tranquility, as seen in 2025's border chaos. Theoretically, this reflects Baudrillardian hyperreality, where legal constructs fabricate a reality where protected characteristics supersede citizen rights, subverting order through subjective chaos. Historical Jewish tactics, like 1084 Worms charters using vague privileges, prefigure this strategy, with intervening acts like the 1990 Hate Crime Statistics Act amplifying data for protected class dominance. The ulterior motive, disrupting white societies through immigration, has succeeded, with 2025's legal morass countering traditional protections, fulfilling a multi-generational design to subjugate host populations under the weight of contradictory laws. Part 4. The chaotic legal morass and multi-generational subversion. The current legal landscape in 2026 represents a chaotic morass of subjective and subversive laws, stemming from hate crime origins, that counter each other and undermine citizen rights, fulfilling a multi-generational plan of subjugation. The Civil Rights Act of 1968's vagueness expanded into the 2009 Shepard Act's broad jurisdiction and the 2021 COVID-19 Hate Crimes Act's new categories, creating a tangle where protected classes supersede all other legal frameworks. The 14th Amendment's equal protection, misinterpreted through 1964's Title VI, clashes with Fifth Amendment due process, prioritizing illegals and minorities over citizens, with 2.5 million border encounters in 2025, Customs and Border Protection, exemplifying the chaos. This morass, with cross-references like the Fair Housing Act of 1968 and 1988 amendments, has evolved into a system where subjective intent and incitement laws, seen in UK's Public Order Act of 1986 and Scotland's 2021 Act, punish speech questioning immigration or protected classes. The Hate Crime Statistics Act of 1990's data mandates, paired with omission policies from 2014 reducing black suspect mentions by 30%, Sentencing Project 2018, create a contradictory framework that shields invaders while disabling citizen response. Historical Jewish legal tactics, from 1881 Russian May laws to medieval charters, prefigure the subversion, with intervening acts like the 1991 Civil Rights Act's disparate impact suits piling onto the mess, rendering order a distant memory. Theoretically, this chaos aligns with Derridean difference, where legal meanings differ indefinitely to favor protected classes, subverting societal stability through a Habermas-style colonization of the life world. The multi-generational plan, evident in 2025's immigration crisis, reflects a subversive intent to disrupt white civilizations, with laws like the 1975 Voting Rights Amendments and 1980 Civil Rights of Institutionalized Persons Act contributing to a framework that counters itself, prioritizing illegals over citizens. This culmination, from 1968's initial design to 2020's excess legal tangle, fulfills a historical strategy of subjugation, leaving a legacy of chaos that undermines the very fabric of national identity. Conclusion: hate laws to invader protection. The evolution of hate crime laws from their inception in the 1960s to the chaotic legal landscape of 2026 encapsulates a masterful orchestration of subversive intent, weaving a complex tapestry of control that has reshaped societal norms. This framework, born from a deliberate distortion of justice, has expanded into a web of protected classes that supersede citizen rights, turning equality into a weapon of domination. The cascading effect, from initial bias provisions to immigration chaos, reflects a strategic design that prioritizes certain groups over the host population, leaving a legacy of legal ambiguity that fractures the essence of national sovereignty. The historical echoes of this subversion reverberate across continents, with the legal morass in the United Kingdom and Europe amplifying the American experience, where speech is policed and borders dissolve under the weight of contrived protections. This global network of enforcement, rooted in a multi-generational plan, has transformed societal stability into a battleground of competing interests, where the original intent of law has been inverted to serve a singular agenda. The interplay of intervening policies and expanded definitions has created a system where the very tools meant to protect have become instruments of oppression, a testament to the enduring power of strategic manipulation across time. Theoretically, this evolution aligns with Hegelian dialectic, where the thesis of hate crime laws provoked an antithesis of profiling disparities, synthesizing into a chaotic solution of omission and immigration dominance that subverts order. Gramscian hegemony frames this as a colonization of cultural and legal spheres, where elite actors impose their worldview, supported by Foucault's power-knowledge paradigm that constructs bias as a tool of control. Nietzschean will to power drives the relentless expansion, while Spinoza's conatus sustains the adaptability of these laws, ensuring their survival through perpetual renewal, a design that mirrors historical precedents of infiltrated governance. The culmination of this journey reveals a society ensnared by its own legal constructs, where the initial subterfuge has blossomed into a pervasive dominance that challenges the very notion of freedom. This legacy, forged through a blend of historical tactics and contemporary policy, stands as a monument to a calculated strategy that has outlasted generations, embedding chaos into the fabric of modern life. The absence of resistance has allowed this subversion to flourish, leaving a future shadowed by the weight of imposed norms, a stark reminder of the power of intent to reshape civilizations unless confronted with unyielding scrutiny.